Well, thank you for joining us. It's 2021. Brave new year, Julian.
It is.
Thanks for being here, buddy. Look, we've got quite a bit to get through today, and there's been a bit of a sneaky because they're driving the pack live today. So for the first time, as some of your questions go through, they're actually going to build it into the pack. I'm not sure where, but we'll find out when we get to that slide. So hopefully we can answer the questions. We'll wait.
It's going to be a thrill,
it's going to
regardless.
It's going to be a thrill. It's a bit like being on a roller coaster, I think. We'll find out how we go. Clearly, want to talk a little bit about vaccines, and hopefully we won't become too contentious when we go into that. Obviously, a lot of conversations at the moment still about people not so much returning to work, returning to the office or returning to the workplace is probably a better way to put it. A lot on the agenda with the federal government's omnibus bill to change the Fair Work Act. I'm going to have a little bit of a chat about that today, talk a little bit about what's in it and what might happen. And then lastly, there's just three or four things sort of on the horizon. Some are still going. A couple of things that probably happened late last year, which I think just worthy of note to make sure people picked up on. And as always, we'll take your questions, bring them through. We'll do our very best to answer them. And as I said, for the first time, some questions will actually pop up live on the screen. So we might kick off.
Let's go.
And we're back in armchairs. It's been a year.
It feels good.
It feels good. I'm feeling relaxed. Didn't have to wear masks to come in today, so we should have a good day. So let's start with the vaccination issue because it's probably one of the first topics that most people are talking to us about at the moment. And look, I'm going to say up front, we're not doctors. I know almost everybody in your family, Julian, is a medical practitioner except yourself.
I am not.
You are not?
To almost their clinical disappointment. I am not.
You're the black sheep of the family.
That's right.
There's a couple of things we want to say about the vaccine, which sort of feeds into then this whole question about can the employer make people have it? And I didn't know these things until we started to look into it a few weeks ago. Number one, when people say vaccine to me, I automatically think that it's something you take to stop the spread of the virus. And that's not currently understood to be the case. And I should just say a couple of things. There's the virus, which is called SARS-CoV-2. And if you have that virus, you then, some people can contract the disease, which is called COVID-19. So just understand that up front. The vaccines that have been trialled to date, most people have heard about Pfizer, Moderna, AstraZeneca. Those vaccines have been demonstrated that if you actually contract COVID-19, they work very well to suppress the severity of the disease. The clinical trials haven't demonstrated yet whether or not it stops spreading the SARS-CoV-2 virus. So there's a little bit of a distinction there before we get into what the rights of an employer are.
The other thing to flag is, it's amazing that they've come up with anything in the time that they've had to prepare something, and the situation is developing all the time. So there's new strains developing all the time. So the fact that there are unanswered questions about this, or that the research isn't there, isn't a criticism at all of anyone.
No.
It's just how science works.
And I think as part of that as well, look, obviously we'll learn more and more as time goes by. For instance, we might learn that it actually does have an effect, or one of these vaccines does have an effect to stop the spread of the virus. But we don't know that right now. We haven't got any clinical evidence of that. And I should just say, appreciate that for some people, vaccines are a little controversial. I don't know what you're doing. I'm going to have it.
No, I'm getting it when and if I can.
When and if you can.
Yep.
Yeah. Not sure which one we'll get yet, but I'm going to get it. So what do we know right now? As we said, we know that the vaccines that are currently available, if you actually contract COVID-19, the disease, it materially reduces the severity of the disease, and in most cases, it'll stop you having to go to hospital and be on those ventilators, which is really important. What we've said, though, is at the moment, the clinical trials have not established at this stage that it stops the virus spreading, and therefore, from our perspective, you couldn't claim that asking people to have the vaccine would stop the spread of the virus in your workplace.
It might be good for that person, but we can't say right now that it will prevent that person bringing it into your workplace and then spread it to everyone else. It might, but we don't know.
We don't know that. So that's a really important issue, which brings, and I know you don't like my cartoon. You've said that already. You're not a fan. Which brings us to the $64,000 question. Can the employer direct an employee to take the virus? And
The vaccine.
sorry,
We almost went down a very dark path there, Nigel.
very dark path there. Can an employer direct an employee to take the vaccine?
Excellent.
One of the vaccines.
Yes.
The vaccines. And I think we might break this out a little bit. I think it's probably best to break it out. And let's just start right at the beginning. Obviously, an employer has the right to give an employee lawful and reasonable directions. Question number one, would it be a lawful and reasonable direction to tell an employee they have to take the vaccine? And look, and we'll talk about this a little later on when we sum up, but the answer is possibly in some circumstances, possibly not in others. And so let me just give you some context for that. If you are working with vulnerable people, if you are working, say, in an aged care facility, I think there's a very good argument that it's both lawful and reasonable for that person to take the vaccine. If you're just working, say, in a plastics factory, I think it would be highly questionable whether or not that was the case. So from our perspective, the ability for such a direction to be both lawful and reasonable is very much the context of the workplace and the nature of the work that's being performed and who you are working with, both as co-workers and also potentially clients.
I think that's right. The contentious point isn't whether it's lawful or not. It's clearly
lawful.
There's not going to be a law against directing your employees to do this. It's a question of whether the direction is reasonable in your circumstances. And as Nigel says, it really will depend on what type of operation that you're running.
And more likely with vulnerable people, yes. As we move back away from that sort of environment, more likely no. There's a lot of discussion at the moment about, well, surely I can rely on my work health and safety obligations. I would probably say this, I'd be more comfortable with that if the vaccine stopped the spread of the virus. I'm less comfortable with that in an environment where it doesn't stop the spread of the virus. It just means that you're personally, if you get the disease, likely to have less of an issue with the disease.
The way I like to think about that distinction is, I mean, it probably would be good personally if employees didn't smoke, but whether you can give them a lawful and reasonable direction not to smoke
or not to drink
for their own health benefit.
Not to skydive.
Exactly. It's not necessarily going to get you there for the vaccine purpose. It really needs, or it will help a great deal to have that extra element. Will it stop the spread? And therefore it becomes more and more reasonable depending on your context.
Exactly right. Look, we shouldn't rule out the fact that some people, particularly in certain sectors, have very clear express obligations in employment contracts around these things. So don't rule that out. We've got a number of clients who work in sectors dealing with what we describe as vulnerable people, where there's contractual obligations to have the flu vaccine and things like that. So as always, please make sure you're checking your employment contracts, because there might be something in there which really guides you as to what your rights are in this space, which means the boxes on the left-hand side are less of an issue.
There could also be something about the conditions, your lawful and reasonable direction rights, the types of things you can tell employees to do. I mean, it's a key concept. Always look at your contract. Always look at your contract.
Start there first.
Exactly.
Start there first. And then, look, we then get into, and we'll be a bit careful here because you and I aren't very good when it comes to politics, but we then get into the question of public health orders. I'm very mindful that the Victorian government, I'm going to say last year, but I think it actually was probably 2019, actually issued a public health order requiring certain employees, I should say more than employees, certain groups of people to have the flu vaccine. I think it was predominantly around aged care, working with people with disability, to have the flu vaccine. So there is precedent in Australia for a state government to issue a public health order requiring some form of vaccine to be taken. On this occasion, it would be probably highly helpful if the various state governments and territory governments issued public health orders. They've been issuing public health orders all the way through the pandemic as it is, about working from home, working at work, being on public transport, you name it. All of those things have been done through public health orders. There's nothing legally to stop the government issuing public health orders about who must have the vaccine. It would be highly helpful for employers to have that clarity. I just don't understand the politics of it myself about whether or not a particular state government might or might not do that.
It's essentially taking the question out of the employer's hands and saying, well, this is law now, you have to do it in certain industries. It's very unlikely, in fact, it's not going to be the case that a vaccine will be mandated at large.
No.
It ended very badly for the UK government in the late 19th century, in that obviously we can't understate the fact that requiring people to get a vaccine is a fairly serious requirement. You have to go to a medical health setting, you have to get an injection, something's coming into your bloodstream. It's not going to be those kind of public health orders and the legislative process that parliaments might enact. That's going to be a pretty small subset. But for those health industry type scenarios, I think it's possible because, as you say, there's precedent for it.
When you think about it, probably the whole labour hire industry is probably keen to have some clarity as well. That would be a good example. A lot of labour hire work in the health sector, aged care sector. So it's not just those sectors, it might be people feeding labour into those sectors as well. So look, we'll just watch that space. If any government decides to actually initiate something through public health orders, as always, we'll let you know as quickly as that comes out, as we've been doing through the pandemic. So those are the primary considerations, which kind of puts us in this slightly grey zone of can the employer direct an employee to get vaccinated? Potentially, yes.
It's a very firm advice.
It's a very firm piece of advice, isn't it? It's a very firm piece of advice. But it's really going to be contextual to the nature of the work they're doing, the workplace, and who they're working with. And if you've got any doubt about that, look, please give us a call, and we'll talk you through it. As we've said, more involving vulnerable people, yes. Less involving vulnerable people, probably no.
I think there's also something to be said for if you're in the quarantine game, so to speak, or if that's
got to be a walk-up start, hasn't it?
You would think so. You would think so. To the extent that for whatever reason you're dealing with COVID as an issue, whether it be in a health context or a quarantine aspect, you would think that you'd kind of be on pretty firm ground.
I'll go further than that, and we'll see. But my view would be that if you're actually working in a quarantine hotel, I'd be very comfortable you give the direction. Obviously, you've got something we'll talk about in a minute, which is that discrimination issue, but I would be very comfortable to give that direction. I don't have a problem with that one. And that brings us to what happens if there's a refusal. And the bottom line is really, given that you're adopting the view that in your situation it's a lawful and reasonable direction, then frankly, with this one exception that we have on the slide, you would simply be walking down the normal performance management path, dealing with somebody who's declined a lawful and reasonable direction. Obviously, the first question you're going to ask them is, why? Why have you said no? And that's a really important issue to understand. It might then turn you down performance management. But the one thing we would say that if the motivation for saying no possibly comes under the auspices of something that might trigger direct or indirect discrimination. So, for instance, let's say they suggest it's on a religious ground, which might then lead you into questions of discrimination. If that's the case, if the why leads down that direction, then please, that's the one time we really need you to pick the phone and have a talk to us before we carry on. Absent that, though, if it's just I don't want to, then we're just moving down the normal performance management path.
You asked the question why for your benefit, not for the employee's benefit, so you can make an assessment as to, well, how reasonable is your direction. If they are saying no, because as Nigel has said, they've got a religious belief which prohibits them taking the vaccine, or if they've got a health issue, which means that there are going to be risks inherent in taking the vaccine, you need to know that before proceeding down.
A good example at the moment, I suspect, would be something like this. On all of the material we've read today, and I preface this statement on that, it appears that none of the trials involved women who were pregnant, and none of the trials involved women who were breastfeeding.
Yep.
That there might be some legitimacy to those people being concerned about taking the vaccine. I would think there would be. So that would be a good example where obviously you don't want to be performance managing somebody whose motivation for saying no is their pregnancy. That would move you into the discrimination world straight away. So the why is important. If the why is complicated or it's got that sort of overarching feel of moving into that discrimination realm, please, that's the one time you really need to pick the phone up. Absent that, it's really standard performance management. Oh, look, she's got us. She's got us.
Oh, here we go.
Okay, here we go. Here we go. Who falls under vulnerable workers and what industries? I'm going to have a crack. Look, vulnerable workers is effectively a sort of what we call a term of art. It's not a legal term. It's not a scientific term.
Yet.
Yet. No, that's true. It's true. It could become one, but at the moment it's not one. What we're largely talking about is people who, in the ordinary sense, might have compromised health or might have higher risk because of health issues, and that would be normally people over a certain age. It might be people with pre-existing medical conditions. It might be people with a disability. So, look, it's around that, and that brings you into, Australian Disability Enterprises would be a good example. I'd throw them into that sort of group. Aged care facilities would be another. We'll come to quarantine. I see a question. I think it's a question about quarantine down there. Yes, there is. I thought there might be, but it's really around those industries. But it's not a legislated term at this stage. Obviously, if you're in a plastics factory, the answer is no.
Well, certainly on the industry front, I mean, conceivably you could have a health condition working in a plastic.
That's a specific case.
That's right. Yeah.
If I can require my employees to be vaccinated and they refuse, can I stand them down without pay? Okay, we could probably spend an hour talking about this question.
It makes me a bit nervous.
It makes me a bit nervous, this question. I'm going to say, look, can you just be very, very careful with this proposition? If somebody is declining a lawful and reasonable direction, this is one of those where please ask us first before you do this. There's a very particular part of law about not paying people. It doesn't really arise in this situation. Even the phrase stand down is probably not entirely correct. Bottom line is this. I would suspect that the employee is, for all intents and purposes, ready, willing and able to work. I'm making that assumption. If they're ready, willing and able to work, you cannot put them off pay. If they're refusing to have the vaccine, we were suggesting that what you're really doing is going down, as we said before, that performance management route. There may be some cases where, for instance, if you were working with vulnerable people, particularly vulnerable people, where it was a lawful and reasonable direction, there possibly could be some cases where you could say, well, because they failed to get the injection of the vaccine, they can't meet the inherent requirements of the job. It's a possibility.
It's a possibility,
but it's
Nigel.
really out there.
The thing is, the question's about standing down without pay. I mean, I could count on one hand the amount of times
you have a legal right to do that.
Absolutely. Yeah. Now, there's actually, interestingly enough, there's a commission case about a vaccine refuser in COVID who was a casual, and after her refusal, she stopped getting shifts. It's kind of standing down without pay. It's been determined that her employment is over, and so she can run an unfair dismissal. So I think if you stood someone down without pay on the basis that they refused to be vaccinated, it's very likely that would be deemed a constructive dismissal.
Yeah, so look, don't jump into that. Pick the phone up before you do. If they refuse, can we direct them to wear PPE? Look, you've got not only do you have a right to direct the working of appropriate PPE, you've got an obligation actually to provide it and make sure people are using it properly. So look, PPE shouldn't be a problem here. In fact, in all given situations, if personal protective equipment is appropriate to the work situation they're in, you should be providing it and people should be wearing it. If we attend client sites and they're vulnerable, nursing blah, 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 who stipulate few shots, how do we deal with staff who won't get it? Look, complicated question. A lot will depend on the extent to which that refusal really makes it difficult for that person to perform their job. If it's just one site and they're able to be reallocated in other places, I would suggest that you're probably not going to be looking at sacking that person. If that simply made it impossible for you to practically use that person, well, that might lead us to a point where we've got grounds to terminate.
Question of degree.
Question of degree, yeah. And okay, there we go. If we're a quarantine facility, e.g. hotel, what can we do if employer refuses? Look, I'll go out on a limb here. I think the quarantine facility is possibly my no-brainer. I think it is both lawful and reasonable. subject to any of those discrimination
I'm not as bold as you, Nigel. I'm going to say I'm going to want to know what they're doing in the quarantine facility.
Okay, well, I've made an assumption that I'm going to make an assumption by that question that they're actually in contact with people who have been isolated because there is a risk of those people actually having the virus, possibly the disease. Yep. I'm making that assumption. You're right. If they were involved in the quarantine facility, but they were not involved in having potential contact, you're right. I probably have to moderate that answer a little bit and step back. I'm thinking about the people who are probably going in and cleaning the hotel rooms and all of that.
I also heard something overnight that suggested that those very people might be the people who can first access the vaccine. So they will.
That would be excellent, wouldn't it?
Yeah,
that would be excellent.
Makes sense.
Look, I suspect most of them will take it.
Yep.
I suspect they will. But again, if it's a lawful and reasonable direction and there's a refusal, subject to questioning that discrimination issue, it's a performance management process. Where can and how an employer draw the line of not offering COVID vaccine to staff? Look, really an HR question, I think.
Yours, not mine.
Yeah, I'll take it, not yours. My sense at the moment is particularly large employers tend to provide access to the flu vaccine on them. Look, this is going to be about your values. It's going to be about how you normally do these sorts of things with your staff. It's your call. It's not a situation where you're obliged to provide it or not. What I would do is if you actually are requiring people to do it, I'd encourage you to pay for it. I think that adds to the reasonableness of the direction. So I'd be encouraging you to do that. But I think this is very much about how you operate as a business in your HR position.
Going to have to see how the rollout goes. I mean, the whole rollout might be bigger than the idea of employers, encouraging their staff to go get it. It might be more structured than that, and hopefully we can get some.
So that's the vaccine. We'll see. As things develop, we'll let you know. Let's just jump in. That took longer. We had more questions than I thought we'd have. That's quite interesting. Let's just jump into returning to work, or as we've described it, returning up. Is this your favourite comedy show?
It's one of. It's exactly like ABLA. Spinning image.
I'm not sure who you are and who I am, but we'll worry about that later. Look, there's probably 3 or 4 really important things to talk about. The first one is the world's changed a little bit since COVID kicked in. If you think about it, pre-COVID, people made requests for flexible work, most likely under the Fair Work Act, possibly under enterprise agreements. Obviously, the big test then was whether or not you want to refuse those requests. Is the refusal based on reasonable business grounds? I have to say that the bar's probably changed a little bit around that since people have been working at home. Only in this sense, I think in a lot of places people have proved they can, at least to some measure and for some time, successfully work at home, which probably just changes the question of what reasonable business grounds might be a little bit. I don't want to go out on a limb with that, but I think that's possibly true.
I think it is possibly true. I don't think you can understate that just because businesses have been able to function for a year,
they must therefore function,
and they're functioning at their optimal level, or that there haven't been severe drawbacks for the huge change in arrangements that we've had. But I do think it does move the goalposts a tiny bit. If not because every second article you read in the newspapers is about how great working from home is and how it's perfect and we should never go back to work.
Yeah, which we'll come on to.
Yes, we will.
Look, I think number one, and we'll come on to Vic and West Australia in a minute, all of the public health orders now, and I'll ask about Vic and West Australia, the default again is the workplace. So just understand that for about a year we had the default at home and the exception was the workplace. The default now is the workplace, the exception's at home. Now, when we talked about this a little while ago, Vic and West Australia were still.
So Western Australia, I think, had just gone into lockdown when the slides were created. So that's the lockdown, as I understand it, has finished. The reason why I say understand it, if you're in Victoria and Western Australia now and you don't know the status of the public health order, I would be very surprised. You will know what is going on. Victoria is different, and it's not the default. In Victoria, if you can work from home, you obviously can't be forced to work at the office. And interestingly, the converse is true. If you can't work from home, you can't be forced to work from home.
Yeah.
So there's also been changes to the Victorian caps, as Victoria has dealt with some issues in recent weeks. But things are, on the whole, if we were speaking to the whole country, which I'm sure we are, it's getting back to a place where the workplace is the default and the home is.
Look, and one of the things, because I'll make a comment about this a little later, but one of the things I want people to be mindful of is increasingly over the next little while, how you draft your employment contracts and identify what the work location is going to be increasingly important. So I just want to sort of throw that out there and make sure people are thinking about that going forward. When
Also, what is in their contract now?
What is in their contract
Go and look
now?
at the contract, because it might be very helpful, or it might be something you need to think about if it's very specific about a particular place.
Particular location. Just remember as well, JobKeeper is coming to an end. We'll talk briefly about this before we finish. But if you've been giving JobKeeper directions to direct people to work in different locations than they normally would do under their employment contract, that's coming to an end as well. You're going to have to deal with it. Obviously, anybody working from home, work health and safety considerations apply. I'm going to say at the moment that this is a bit of a moving feast. There are some guidelines in Queensland. They're incredibly detailed, the Queensland guidelines. I'd suggest if you're in Queensland, you get a copy of those. There are some guidelines in New South Wales, which I've read. They're less detailed. The Queensland guidelines all deal with ergonomics and all sorts of things. But you know, if you have people working at home, you need to still be aware of the fact you need to make sure that they're working in a safe environment.
I actually think work health and safety is in this slide because people are coming back to work. So obviously, if people are coming back to work and you haven't been there for a while, or the world has changed, we're all thinking we're all getting the sanitizers. We understand the masks. We understand that in some cases the temperature checks, the check-ins, all of these things.
We've adopted the QR code for our office.
We have,
which is working very well.
So that's something to think about. It's possibly one of the first things to think about when coming back to work. Well, is the office, the factory, the childcare centre set up?
Just understand that these obligations are cutting both ways. And we'll talk about, because one of the things we want to talk about later on is about, we've got some people who are saying, can they stay home?
Yep.
I prefer that now. But also understand that, as Jill said, as people come back, just make sure that we're rethinking work health and safety obligations as people come back into the office. And I think most people, they're big on sanitisers, they're big on office space, so they're making sure that the right office space when people are coming back. So I think we'll talk about what people are doing a little later, but I think most people have got that in their minds at the moment, but they need it. As the world comes back to normal, obviously people will start thinking about potentially making formal work requests for flexible work arrangements. It's a good time to review policies and procedures about that. And we've got a lot of clients at the moment who are doing it. And I think we've just thrown in there that last one, which is as you bring people back in, some people might not want to come. And again, we need to understand why. There might be a legitimate reason why, which brings you into that discrimination world again, particularly if we've got people who themselves have compromised health. And we had somebody the other day who's suffering from anxiety and a distress order about the idea of getting on public transport. So just be very mindful that, again, if they refuse to come back, there is a why there that we need to go through as well. We need to go through that. Have we missed anything, Jules?
I don't think so. I mean, I was going to say about flexible work requests and policies, to the extent that your employees have been at home for what could be a year, some of them may have moved house into another part of Australia. They are going to be making a flexible work request, either under a policy or under the Fair Work Act, to work from home indefinitely, because people have changed their lives.
This is actually true. We know of people who've said, "Well, I've now moved to Brisbane. I should have told you."
You're gonna have to deal with that. And again, it comes down to what might be in your policy. It comes down to whether you can facilitate or accommodate what their request is. And yes, some interesting times ahead.
Wow. Okay. Well, I'm going to say thank you for putting all these in.
What's everyone doing?
What's everyone doing? That's a good question. My answer is this: I don't see anything uniform. I think the majority of people at the moment are adopting an approach of graduated return. I think most people are. Most people at this stage, it's February now, most people I think have got people coming back for, say, 3 days a week, some 4. We do have quite a few non-office environments, frankly, that have probably been working as normal for the whole time.
I was going to say that there is a white collar bias
blue collar thing
to some of what we're
is,
saying. For a lot of people, they've been on the tools
on
for
the
a
tools
while.
the whole time.
Yeah.
On the tools the whole time. So, but for people in that office environment, I think the majority of people we're talking to at the moment are back to work in some fashion. And I think the motivation for that is, I think a lot of people were getting, frankly, a little worn out being at home the whole time. I'm sure there were some mental health issues for a lot of people. It's really good to get back together with the team. And certainly for younger people, what we've probably noticed talking to a lot of our clients is younger people have probably felt left out. They're missing out on development. Mentoring. So I think there's a general trend at the moment, I'd say, for people who weren't in the office, let's use that phrase, for them to be coming increasingly back to the office. We've got a few clients who are saying, as of this date, you're back. And if you don't want to be back, then you're now making a formal request not to be back. But I'd probably say that's the minority at the moment.
And also a minority is, the idea that whole industries would never return to the office, and
we're not seeing that.
We're not seeing that.
No, we're not seeing that.
Some huge, some high-profile examples and some good media clickbait, but we're just not seeing that in a general way.
And I'd probably put a plea out that the Premier might agree with me, which is, economically, we do kind of need to get the city going again, because the amount of economic activity in that city is really, really important. How do I get people back to the office? Well, there's probably an HR answer to that, and then there's probably a legal answer. The HR answer is probably what I've suggested, which is some sort of engaged, graduated return. From a legal perspective, assuming their contract of employment designates the office as their workplace, then eventually, if you feel the need, you can direct them back. And then we're simply looking at possibly 1 or 2 isolated cases who might have a legitimate reason not to be coming back. Probably the big thing I've found personally is reticence to get on public transport, and possibly those people who live a very long way away from the office, combined with taking public transport. That's probably the group that we've probably seen needed the most encouragement to sort of come back, probably that group. But look, at the end of the day, subject to an individual potentially having a right to decline, the answer is if push comes to shove and their employment contract says that's their office, you direct them back to work. That's the way you do it. Employees refusing to return to work due to health concerns. Well, I think we've sort of covered that. It would be like any other situation where somebody says, I can't come to work for a health concern. You probably need independent medical assessment. You need to understand the extent and severity of the health issue. I'm going to be careful when I say this, but the legitimacy of the health issue. And you would just treat that as any other worker who said they have a health concern which prevents them from turning up in the workplace.
Yeah, and again, I would say to that question, engage in a dialogue, ask questions, work out what their anxieties are, what their health concerns are. If those health concerns are not material, or that you can mitigate them, or maybe you can satisfy the employee that they're you can deal with it.
Yeah.
So,
yeah, no, good question. I love this question. It's great. Can an employer require its employees to return to the office full time with no further work from home arrangements except those allowed under the Fair Work Act to request same when government restrictions allow that to occur? Look, I'm assuming by full time that means not as full time employees if they were part time employees. So I'm assuming by full time it means you're back to the office. I'm not going to let you work from home anymore unless there's a formal flexible work arrangement request. The answer to that is very simply yes. I'm assuming their employment contract identifies the office as their primary work location.
people have done that. I mean, this is happening right now.
This is happening right now. So look, the answer is yes. If you've got any problems, as I say, with people saying no, we need to drill down on the why and make sure that there is not a very specific, legitimate reason for that individual to decline, because there may be in some cases, particularly for health reasons, there may be. Although as the virus dissipates in our community, I would even think they're diminishing as well. They're diminishing as well. Can I ask my employees to work from home ongoing? Oh, great question. Ask away. Ask away. I'd say ask away. The answer is yes, you can ask them. Some people are doing that. We've just acknowledged that. I'd probably say a number of things. If you can reach an agreement with them to do that on an ongoing basis, I'd be very careful about making sure I understand contractually how I'm writing that down for the go forward, so that if you change your mind later on, there's no confusion. That's proposition number one. I would say proposition number two, if they refuse, then you'd have to look at your employment contract and see what is designated as the work location. I sincerely doubt their home is designated as the work location.
That's right.
So they can refuse. And if you're going to ask them to work and they agree to work from home on an ongoing basis, I would suggest your WHS obligations have just jumped up.
Yeah, so I would ask the questioner, I would question the questioner, are you ready for your employees to work from home ongoing? So are you ready to satisfy your WHS obligations? Technology obligations, or what you need to do about technology. Are you ready to performance manage someone working from home?
If they're regulated by a modern award, how are you going to let them work from home in the context of the modern award?
Precisely. Do you know when they're going to be working? Do you know? There are a lot of questions to ask oneself before going down that path. It's an entirely available path, and you can certainly ask, but it's a complicated thing.
So I think the answer is, look, yes, you can ask. If they decline, that's a different issue. But if you really want to do that, as Jill said, there's a lot to think about in this space, and probably give us a call and we'll take you through that. Can we expect union claims about working from home? Absolutely. More than likely this year, there may actually be an employer application in relation to this, in relation to modern awards. Failing that, I would truly suspect the ACTU will be filing something this year. Whether or not that's dealing with very discrete issues like providing technology or whatever, or whether or not it's a far more sort of holus bolus case, we'll wait and see. But I think it would be very unlikely that there isn't some form of modern award case this year focused on working from home.
It's a big shift, Nigel, and the idea that you can easily apply modern awards and the Fair Work Act to people working from home exclusively.
Particularly self-regulating, who are self-regulating their hours, is going to be an issue we're going to have to address. And I think the Fair Work Commission is aware of that, and I suspect 2021 there will be a case. Which brings us to the bill. Now we've taken longer than we thought, but we'll crack on through the bill. Quite a bit to cover. Look, we're not going to get into the granular detail. How many pages was it? I've forgotten. Okay, quite a few. There you go. Jill's brought
I was going to read it all out.
Were you going to read it all out?
You probably should just mention it is a bill. So the idea that this is going to be the law and that all of these things are going to come into the law, that's optimistic.
It's politics.
Yeah, it's politics. It's politics.
It's politics.
Optimistic not because I want these particular
You're advocating
changes.
for or against?
Optimistic because I'd like to, learn some new...
There's some new law.
New stuff,
law. So look, probably quite a few topics, but we'll scoot through them and we'll just pull out the highlights if we can.
Yep.
Look, everybody knows the whole debate about what is a casual is a live issue. We've got Workpack and Scheme. We've got Rosato, tell me if I'm wrong, still going in the High Court?
I believe so, yes.
Still going in the High Court. This whole question about what is a casual and whether or not certain classes of people who got casual loadings actually are also entitled to annual leave and everything else. So it's a really live topic. Government's tried to address it in the bill. I'm a little grumpy about this one because it goes for about 8 pages, and I reckon it could have been done in about 8 lines. But just if it's all you're smiling, I know.
They're trying, Nigel.
It's right.
They're trying.
There's a lot
of issues. I mean,
it's all about how the contract's formed in the bill.
That's right. So defining the casual employment is probably the easy part, because what they've tried to do is just take the law, the common law, and put that in legislation. So a casual employee will be an employee who has no firm advanced commitment of continuing work and on an agreed pattern. So that's what the courts say. The difference with this is that in this omnibus legislation, the changes to the Fair Work Act, what will happen is You just have to look at the formation of the
It's
contract.
all about the formation. It's not about what happens afterwards, which is all about Skeen and Rosado.
Exactly.
It's not about what you pay them. It's about how you form the contract.
Once a casual, always a casual. Are they described as a casual? Do they get a casual loading? Can they refuse work, refuse shifts and take shifts? You will know, if this law passes, whether you are a casual. Everyone will know from the point of conception, engagement.
The important thing, I think, for the viewer to understand is if this gets up broadly in the form it's in, there's probably a piece of work for most people out there to review their letters of engagement, their employment contracts with casual employees, to make sure they reflect what they want in the relationship and how it matches up to these new laws.
That's right. It may be that your contracts
Are fine?
It's easy to get, if this gets through, it will be easier to get right. And one thing that won't happen, can happen now, is that someone can start as a casual and then morph into a permanent employee.
That won't happen.
Won't happen.
That won't
happen.
And look, there's a variety of other things attached to all of this. Most of the modern awards today have casual conversion in them anyway, but that's not going to jump into the national employment standards.
That's right. It's a slightly more restricted casual conversion entitlement than is currently in awards.
In some awards.
But that's in there. We've got a casual employment information statement.
New piece of paper an employer's got to hand out.
Precisely, like the Fair Work.
Gotta love bureaucracy, don't you?
The Fair Work information statement as an attachment to that. So that'll be fun. The last point is offsetting casual loading amounts against claims for leave and other entitlements.
This guarantees no double dipping. So if you are one of these properly contracted casuals, you never have to worry about paying the casual loading and having a court come along later and say, in addition, you now must give them annual leave.
Yeah, so I think this is a real belts and braces approach. I don't think anyone will really actually need. I don't think court will need to apply this rule because I think you can get it right at the engagement.
You're in.
Zone.
Okay, well done. So look, big ticket item I think in the legislation. It's probably a fairly discrete issue, but there's this new machinery in the legislation trying to provide additional flexibility to employers around part-time employees. And in a nutshell, this is if employees, so let's say an employee is contracted to work 15 hours a week, the way it works, you can make an agreement to work them 16, 17, 18 without the payment of overtime until you get to 38 hours a week. That in a nutshell is the gist of it.
That's the gist. Some of the numbers need to go up and down, but that's right. This is a story that's been run a couple of times in the last few years. The idea of trying to free up some of the restrictions on part-time employment. You have part-time employment that has benefits for employees and employers, but in circumstances where you need part-timers to flex up, there are occasions where it seems that the payment of overtime to those part-timers is stopping those part-timers getting additional hours. It's only for, I think it's 13 awards are listed for this particular provision.
So it's limited in its scope.
I think by the regs they can actually introduce more awards.
And I have to say that when you read it, it's quite complex how you do it.
It is.
It's quite complex, but just be aware there that that's one of the flexibilities that's in the bill, and we'll sort of watch that space. And it's a flexibility that's in quite a few awards at the moment, modern awards at the moment, but not nowhere near all.
No, that's right.
Yeah.
That's right.
I won't ask you to name them, Jules.
Please don't.
Look, this is possibly the big disappointment. I'm going to say that. I think a lot of employers were hoping there'd be quite material changes to the enterprise agreement process and certainly the enterprise agreement approval process. There's actually quite a lot of changes proposed. It would be unfair to say that they're window dressing, but to be fair, not many of them are really substantive. They're refinement changes. There's probably one or two that are probably worthy of observation. The first one is that at the moment, it is possible when approving an enterprise agreement for the Commission to look at what we call theoretical rosters. This bill, if it passes, will get rid of that, we think that's a good thing.
Seems to make more sense.
Seems to make more sense. You have to actually look at rosters which are live or reasonably contemplated. There's an issue about stopping third parties intervening in the approval process unless they actually were a bargaining representative in the process, and without offending too many trade unions about this.
Dangerous ground now.
We might name, CFMEU is probably well known for doing this, not being involved in negotiations, not being a bargaining rep. but then very substantially appearing in proceedings to try and oppose.
The short point is employer agrees with their employees to a deal, and then third-party union who was not involved, it doesn't have to be a union, but third party comes in to the approval process with a list of issues to raise. I guess
that were never part of the conversation.
That's right, and I guess the raising of the issues is one thing, but also ultimately I think this change is meant to streamline the process of approval so that when a deal is done, it can get approved and people can get back to work.
Let's not say those third parties might not have an ability to get in. It's a very constrained ability. Exceptional circumstances, very constrained ability. Probably what's been controversial is that the bill does say that certain enterprise agreements that fail the Better Off Overall test can still be approved, can still get a pass, and that's largely because of COVID and the recovery.
I think the words are when it's appropriate to do so, and then there's a list of various considerations which include the idea that the business has had a bit of a problem with COVID or coronavirus, and to assist in the revival of the business, we can get a boot.
Look, and it's nice to see there. You could get into a very interesting legal debate very quickly. You can actually get an agreement approved today that fails the boot. The test in that context is called the public interest test. I must say personally, I think that if you had a business that was on its knees because of COVID, and the only way of that business continuing and therefore employing those people was to get a sub-boot agreement approved, I think it'd pass the public interest test anyway. But this has been held up as quite controversial.
It has been. Interestingly enough, the more strident critics of the bill say exactly what you just say. We don't need to expand the exception.
Public interest test anyway.
We've got it already, and this is some mischief by the writers of this piece of legislation to try and create a window for sub-boot agreements.
And probably the one thing that's up there that we should talk about, but it's not on the slide, is I hate the word zombie agreement. It really frustrates me. But pre-Fair Work Act enterprise agreements will have a death date, for want of a way of putting it, where they'll just...
The zombies will be killed.
The zombies will be killed. They will cease to operate. We've got quite a few clients who've still got agreements of that type. We know some unions who still have agreements of that type and want to keep them. But there's going to be a sort of a cut-off point where at a certain date, all of those pre-Fair Work agreements are going to disappear.
I just would be shocked if there isn't consensus on that point. Like, some of these agreements are many years old. In fact, some of our clients, maybe not our clients, some people do not know that these agreements apply to them.
That's true. We've got clients who actually have found out that they've got agreements that technically are still alive.
So I'm yet to meet anyone who is
vigorously opposed.
Opposing the killing of the zombies. So,
a lot going on in the enforcement space. I'll just perhaps cover that quickly if we can. Coalition government has said from day one that it supports jail time for a very discrete class of underpayment. Now, my view is I don't think you should criminalise anything to do with employment. I think it's a disincentive to employment. I've said that for the last 30 years. But it's a very discrete class.
You will be comforted by how confined the potential for a criminal sanction is under the omnibus. It is for dishonest, systematic underpayment. Dishonest being a standard assessed against a reasonable person or the common person, and that is. I mean, the important point is that's not the underpayments that we read about in the newspapers, where there's been an error in
the Woolworths example, which everybody's read about.
This doesn't cover, though. No one is going to jail because they have not successfully calibrated an annual salary against the award entitlement. This is it's very serious, premeditated, dishonest behaviour. So,
and it's only the Ombudsman who can actually bring.
There's actually three. So the Ombudsman, and then there's the Construction Commission,
Building Construction Commissioner. Yep.
And then also the DPP.
Okay, DPP. I hadn't seen the DPP in there. Yeah, okay.
So there's an exception for that, or a carve out for that. So there's the DPP, the FWO, and the construction.
So I think one of the great fears was that trade unions were going to actually start to bring these claims against employers to try and seek jail time, they don't have the right to make the application.
No, just
They could petition the Fair Work Ombudsman, but that's
absolutely.
But it'd be up to the Ombudsman.
That's right.
And probably the other item to just notice is that there's going to be more involvement of the Fair Work Commission in underpayment claims. There's a mandatory conciliation process that the applicant can actually ask the Fair Work Commission to go through to settle the matter. There's no mandatory arbitration.
That's right.
But we can have consent arbitration.
That's right. So not just in terms of just throughout the omnibus, there's various name checks for the Fair Work Commission, but as a general rule, and again, to give you the gist, the Commission is going to play a role in conciliating these matters as opposed to arbitrating them.
And look, maybe it's because I come from the world of conciliation and arbitration, but I think generally speaking, most people saw that as a good thing.
That's right.
Yeah, try and nip it in the bud, settle it in a friendly environment rather than always ending up in a courtroom. So I think that's a positive thing. How's it going to go? It's in committee at the moment. I think that's right, because there's all sorts of, I think it's in committee and people are actually appearing in front of the committee as we speak. I think I might be a week out with that.
Yeah, I think we've had Townsville Adelaide. I mean, we're not politicians.
We're not politicians.
So
we're not politicians.
It does seem to me that some people are taking a considerably long run up to try and kick this thing.
Yep.
Obviously, the Labor Party's come out against it. Greens have come out against it.
Well, I suspect the left said it's too employer friendly, and the right have said it's not friendly enough.
It's possible.
And I suspect, we're not politicians, I suspect it'll all come down to the crossbenchers.
This is right. One Nation, I think, have said they won't support it. But I think,
That's always, won't support it in this form probably.
That's right. Yeah, I'm guessing. But it does seem like there will be something along the line, but it will not look precisely like what it looks like now or perhaps what we've just told you about.
I think the takeaway is, look, just watch the space. Just be aware of those headline issues in terms of how they might affect you. When it becomes clear what the law is going to be, we'll be back in the studio. We're going to take you through it in fine detail.
I cannot wait. Okay.
Julian's just volunteered for that one. We'll see. We might actually get three of us. We're going to get Lewis, you and I in there and see how we go with that. But look, something probably will be passed, but probably there's a lot of haggling to go at this stage, and we'll see how we go. Just a couple of things before we finish. We've got about 7 minutes left. I want to talk about some things that you might have missed or some things that are on the agenda, and we'll just see how we go with that. Look, number one, JobKeeper is finishing.
Well, unless it's extended. I mean, you don't know what's going to happen nowadays. I hope it ends because it means that the pandemic is getting progressively better in Australia, but I don't know.
But at this stage it is, and importantly, if you are the subject of JobKeeper directions, that is, you're an employer who's given JobKeeper directions, you really need to start thinking now about what you're going to do as an alternative. Please be mindful that some of what are JobKeeper directions might be in modern awards if you're covered by a modern award. So you might be able to move from JobKeeper direction to directions under some of the modern awards, because some of the modern awards still have COVID-19 schedules in them.
That's true.
So just think about that. Also, you need to then think more differently and more broadly about what directions you can give lawful and reasonable directions under their employment contract. But I'd be saying to most people, if you are currently a giver of a JobKeeper direction, start thinking now about what you're going to do. Let's work on the assumption that JobKeeper probably is going to come off as currently projected. I don't see it going on. I think what might happen, if anything, at this stage, if there is to be more stimulus, it might be very targeted going forward rather than ran at large. General sense at the moment seems to be that in an aggregate sense, the economy seems to have recovered faster than most people thought, which is an incredibly positive thing. So just get a sense of that. Obviously, for a lot of businesses as well, you're going to be thinking about the commercial impact of JobKeeper coming off. And if you do need to start thinking about restructuring your business because of that, give us a call, and that's obviously something we'll talk you through in terms of what your options are and also what your obligations, particularly around consultation and the like, are. But that's going to be a big march for some people, I think, when that happens.
It will. I mean, the JobKeeper regime freed up and loosened up a lot of things that employers could do. To the extent that it ceases, we're back to how it was before. We're back to the old rules in the new world. So it's going to be interesting, and there's some interesting decisions and calls to make.
Now, having said that, there's a little bit of hope on the horizon for some people.
Yes.
The minister wrote to it's the Attorney General, Christian Porter, wrote to Justice Ross, the President of the Fair Work Commission, late in 2020, asking the Commission of its own motion to see whether or not, for a very limited number of awards, certain things could be simplified, introduced. The letter basically, highlighted loaded rates, that is, an all-up rate so you don't have to pay overtime and everything else. It talked about simplified classification structures, and it talked about exemption rates. That is, if I pay somebody over a certain amount of money, then certain clauses might not apply, such as overtime and the like. And the letter basically asked the Commission to focus on what's been traditionally described as the distressed awards.
The ones that got smashed.
The ones that got smashed. Retail, hospitality, restaurants and clubs. I'm personally acting in the restaurant industry for the Restaurant and Catering Association, and we're attempting to introduce some flexibilities there. Dialogue's going very well with the United Workers Union at this stage, but long way to go. And I think Australian Business Industrial, who we act for, they're pressing some claims in the retail sector. Hospitality Association, Australian Hotels Association, have I got that right?
Yep.
Good. Our friends there would be offended if I got that wrong. They've got a number of matters they're looking at in the hospitality sector. I think the Clubs Association were sort of interested, but actually haven't declared their hand yet.
Okay.
So quite a bit to go. But again, if you're running a restaurant or cafe, you're running a retail business, you're in the hospitality sector, it's a watch this space area, because I think there will be some changes in those awards which might be quite beneficial in that simplification space for those employers. And I think some of the things that are being talked about, very pragmatic, and possibly could be very welcome. So please just, whichever association you're a member of, the Business New South Wales, Australian Business Industrial, or one of the industry associations, stay in contact with them, because there's quite a bit going on.
I'm not personally involved, but I've seen the variations and they look quite clean and exciting. So yeah, it's an interesting one.
It's an interesting space. And look, I have to finish on this because if only to say well done to Julian. Most people might not be aware of this, but last year there was a very strong attempt by the Shops Union to remove junior rates from the retail award. And there's been a bit of a trend in recent years of eroding junior rates, knocking them off, certainly for, say, 21-year-olds and the like. And there was a general reticence by some employer associations to defend this case. I think there was a feeling that this case wasn't winnable in the modern world. And to Julian's credit, Julian stepped forward on behalf of some of our clients.
It's really not about me, Nigel. The case was run, it actually finalised last year, but it ran.
So who did we act for in the case?
Australian Business Industrial.
So Australian Business Industrial. And look, very simply put, the junior rates completely or predominantly stayed where they were?
Predominantly stayed where they were. For any classification in retail where you're likely to be a junior, you will still be able to pay juniors junior rates. I mean, from my perspective, I understand the reticence on some parts, on both sides, and it is an incremental project from the people looking to take down junior rates. It does seem like a good time
to keep them,
to be giving young people a go
I agree
in the
workforce. I agree with that. So I think that the reason why I wanted to put it here was takeaway was it would have been the most disastrous thing for the retail sector to get rid of junior rates in the midst of COVID. Well done, mate, for keeping it. It was a good effort, because I think it's a necessary ingredient for making sure that the retail sector recovers. It's got enough problems as it is without this being added to it. So Thanks for joining us. It was quite exciting having the questions actually added into the slides today. Hopefully we answered them on the run well enough. As always, give us a call, drop us an email if anything arising. We'll have a look at the questions we didn't get to today and see what we can do about answering those. Thanks for being here.
Absolute pleasure.
It was good to be back, wasn't it? It was good to be back. And we'll see you next time in a few months' time. Take care.
Thank you.